Subscribe to our YouTube channel and click the bell icon.
Very good afternoon, Advocate Bhushan, and we're truly grateful that you've agreed to have this interview with Bar and Bench. Just to give a small recap to all the viewers who are watching the video, yesterday the Supreme Court of India, Justice Arun Mishra-led bench, found Advocate Bhushan guilty of contempt over his tweet critiquing the judiciary and imposed a fine of ₹1 on the advocate, and also stated that if the advocate does not pay the fine, then there would be an eventual imprisonment or a debarment of practice. However, Advocate Bhushan has agreed to pay the fine, and he has in fact deposited the fine of ₹1. Before we start the interview, Advocate Bhushan, one thing that I really wanted to ask you was, if we go back to the day when you were tweeting on that particular incident, what were you thinking at that point of time? What was your state of mind at that point of time? And did you really think that that particular tweet would one day land you, in this contempt case that happened in the Supreme Court?
I have not paid the fine. I have said that I will pay the fine. I will do that under protest, subject to my right of filing a review as well as a writ petition challenging the judgment or seeking at least an intra-court appeal against this judgment, which should be heard by judges who are different from those who gave this judgment. Regarding your question, you see, so let me concentrate on the more important tweet, which was in three parts. Firstly, I said that in the last 6 years, democracy has been substantially destroyed in this country during this Modi regime, and that the Supreme Court has played a role, that historians will mark the role of the Supreme Court also in this destruction, in allowing this destruction to take place, and in particular the role of the last 4 Chief Justices. Now that was a very, very well considered tweet. It was not, I didn't tweet that in carelessly or absent-mindedly. It was very well considered because I thought that this is exactly what has happened over the last 6 years. That's my view. There are others who may disagree with that view. I know that there are others who disagree with that view.
Right.
But that was certainly my view. And I didn't think that it constituted any contempt. But I know that there are people in my family as well as among my friends who have been apprehensive that since I have been tweeting or speaking quite openly and candidly about what has happened to the court or to the judiciary, therefore they might haul me up for contempt. And I used to tell them that, look, I don't think this is contempt at all. And if I'm not going to say this about what is happening to the court or in the court, then who's going to say this? This needs to be said by somebody, and I should be able to say it.
When I asked you this question, we also come to the fine of ₹1, which was hotly debated yesterday across all channels. Why do you think this fine of ₹1 was imposed? Was it a more symbolic in nature, kind of a fine just to show that you have been convicted, or was it to send a message across? How do you perceive the imposition of a rupee fine?
Yeah, I found it a little surprising because if you read that judgment, most of it is very strong and very vicious against me. And therefore, at the end, this fine of ₹1 seems a little incongruous to the rest of the judgment. And I don't know what weighed in their minds in imposing this ₹1 fine, etc. As I was reading the judgment, I think they were heading towards imprisonment and debarring me, etc.
Yeah.
So debarment could not have taken place without giving a specific notice to me that this is the punishment that they propose to impose. In my view, of course, such a punishment cannot be given under the Contempt of Courts Act. Certainly not for freedom of speech, because speech can only be restricted by reasonable restrictions imposed by law. And the law is the Contempt of Courts Act. And that prescribes a punishment of up to 6 months imprisonment and up to 2,000 years fine.
Right.
It doesn't prescribe any other punishment. Therefore, any other punishment, in my view, is a clear violation of Article 19(1)(a) of the Constitution.
There are still a lot of discussions, Advocate Bhushan, that you should not have agreed to pay the ₹1 fine because it somehow shows an acceptance of guilt. Does that hold any water?
No, it certainly doesn't show any acceptance of guilt. The fine would be paid under protest, subject to my right of review as well as writ petition, etc. And in any case, you see, even if I have to submit to whatever penalty they impose. Now, those who were saying I should not pay the fine and should go to jail were seeming like telling me as if I was itching to go to jail. I was not itching to go to jail. I was prepared to go to jail if that was the penalty that they had imposed.
Absolutely. Especially since you say that the payment of the rupee fine is in protest. So I think that makes it a little more clearer. And sir, is a review petition against the judgment in works?
Yes, it is being prepared, review as well as a writ petition.
Okay.
Which will ask for an intra-court appeal, or at least conversion of the review into an appeal to be heard by different judges. Because the Supreme Court has held that at least one appeal against a criminal conviction is a fundamental right under Article 21. Therefore, they have to devise an intra-court appeal for an original conviction for criminal contempt by the Supreme Court.
Okay. Advocate Bhushan, one important question is, how far do you think Attorney General Keiki Venugopal's submission to the Supreme Court had a bearing on the sentencing verdict of the top court?
I don't know to what extent that had a bearing, but I was certainly very gratified to find that the Attorney General virtually came to my defense. After a long time, we saw an Attorney General behaving like a constitutional authority and giving his independent views and not that as an officer, as a law officer of the government. So I was certainly very, very gratified by what the Attorney General told the court in this case.
Advocate Bhushan, do you think this case would have been or could have been dealt differently if it was a different bench?
Yes, possibly it could have been, because as I had written to the Chief Justice that Justice Arun Mishra clearly has accused me of contempt of court on 3 different occasions just because I had suggested that it was inappropriate for a particular judge to hear a particular case. He said this itself is contempt. And he had imposed a fine of 25 lakhs on the campaign for judicial accountability and reforms. And I had also tweeted once earlier about the fact that he had invited Mr. Shivraj Singh to his residence for the wedding of his nephew at a time when the Birla Sahara case involving Shivraj Singh was pending in his court, which was quite inappropriate. So I felt that there was a reasonable apprehension of bias on my part, and therefore the Chief Justice should transfer the case to some other bench. But unfortunately, that plea was not heeded by the Chief Justice.
Right. Advocate Bhushan, you said that the verdict is a watershed moment in the history of freedom of speech and expression in the country. Our readers and viewers would really like you to elaborate on this particular statement that you said yesterday in the press conference.
So you see, this case became important for 2 reasons. It brought the spotlight on what I had said in my tweet about what has happened to democracy in the last 6 years in this country and what the role of the Supreme Court had been in that. So it brought the spotlight on that, and it emboldened a lot of people, because a lot of people, once this contempt notice was issued to me or this conviction was given, a lot of people retweeted the same tweets with the same statement that I had made in my tweets, right, saying that if I was guilty of contempt, they should also be held guilty of contempt and they should also be punished. Right. So in some sense, it came to be seen by the people as an attempt to muzzle my voice, and it somehow created that defiance in the minds of a lot of people, saying, all right, here is one person who has stood up for speaking truth to power, is not willing to be muzzled, and we are also not going to be muzzled. And therefore now we will also speak truth to power. So in that sense, it became a watershed moment. It has become a watershed moment for freedom of speech.
So the petition, which was filed challenging Section 2C1 of the Contempt of Court Act by you along with Mr. N. Ram and Arun Shourie, was withdrawn. Could you give us some reasons why was it withdrawn?
Yes, primarily because it was listed before Justice Arun Mishra, who had made his views absolutely abundantly clear. Therefore, there was no sense in pursuing. It was in fact originally listed before Justice Chandrachud, and thereafter deliberately withdrawn from there and listed before Justice Arun Mishra.
Yes.
So it had nothing, there was nothing integrally connected between that petition and the contempt cases against me. So it seemed to us that there was no point in pursuing it before a bench headed by Justice Arun Mishra. And therefore we withdrew it with liberty to file it again. They said that if you want to file it again, you'll have to go to a high court, not to the Supreme Court.
Yes. But so do you think courts today are in a position to strike down this particular section of the Contempt of Court Act, or is it being invoked way too much? Only being highlighted perhaps in the media in your case, a lot more than how it is invoked every now and then. Do you think this particular provision in law could be struck down in the near future to come? Do you see a possibility as such?
Well, it should be struck down. It has been withdrawn in most civilized countries of the world, notably in England, where it had been in disuse for almost a century.
Right.
Now it has been formally deleted from their contempt law.
Right, right.
In America, it has not been there for a very long time, and most other civilized countries, this kind of provision is not there.
Right.
Because it is firstly to weigh what is scandalization, what is lowering the authority of the court. Usually the judges think that any criticism of the court or the judges amounts to scandalizing the court, etc.
Right.
Jurisdiction in which judges sit in their own cause, because they are the accuser, they are the prosecutor, and they are the judge in the same matter.
Right.
Therefore, in our view, it needs to be withdrawn or struck down. It's an unreasonable restriction on the freedom of speech. The Constitution only allows reasonable restrictions on the freedom of speech by law for contempt of court. This is clearly an unreasonable restriction, and therefore it should be struck down. And I hope that soon, someday, some court will strike it down in India as well.
Advocate Bhushan, this case was certainly not your first brush with the contempt case. As we all know, there is a 2009 contempt case which is still pending, and perhaps larger questions of law will be referred to a larger bench to deliberate upon the case. How do you see that case panning out, sir?
So I don't know. I mean, there are important questions there as to whether an opinion about the extent of corruption in the judiciary. See, if you want to assess what is happening to the judiciary or the state of the judiciary, you have to discuss what you feel about the state of corruption in the judiciary.
Correct.
Now, Justice Arun Mishra's oral pronouncement seemed to suggest as if even anybody saying that in their perception there is some corruption in the judiciary, that itself amounts to contempt.
Right.
Now, if you don't discuss corruption, how will you reform the judiciary? See, Transparency International had done a study about corruption perception in different institutions.
Correct.
And they came to the conclusion that the people perceive that the judiciary is the second most corrupt institution after the police. The Attorney General pointed out to the court that at least 9 judges after retirement and several Chief Justices, even while they were sitting Chief Justices, had pointed out that there is substantial corruption in the judiciary. So unless you discuss corruption in the judiciary, how will you eradicate the problem?
Correct.
You can't keep on, and besides, you see, uh, the confidence of people in the court or in the judiciary cannot be maintained by shutting up people from talking about corruption in the judiciary.
Right.
The confidence is maintained by the actions of the courts and its judges and their judgments. And if somebody makes a totally unfair or ridiculous criticism of the court, people see it for what it is. Confidence of the people doesn't get shaken by even a very unfair or very negligent or even sometimes even malafide criticism. It is seen for what it is. It is only when the criticism really cuts to the bone and it is made in a very responsible and measured way that confidence of the people in the judiciary can get shaken to some extent, and then it needs to get shaken, because unless it gets shaken, unless people see what is the true state of affairs, there will not be any reform.
Absolutely, sir. So there was a lot of comparison being drawn between your case, the contempt case, and that Justice C.S. Khannan was facing. It was hotly debated that while you had the backing of a large section of the bar, um, Justice Khannan had no one to support him, especially during that contempt case that was panning out. How do you see this comparison, sir?
So, in my view, these were completely different cases. I was being charged with contempt for having expressed my views, my bona fide views about the state of affairs in the judiciary. He was charged with contempt for having abused his judicial office and issuing such orders that Supreme Court judges should be arrested and produced before him and so on. So he was clearly interfering with the administration of justice. You see, criminal contempt is of two kinds.
Right.
One is interference with court proceedings or the administration of justice, and the second is scandalizing the court.
Right.
He was essentially interfering with the administration of justice, and that's why he was charged. So it's an open question as to whether he should have been imprisoned or not, or sentenced to a term in prison or not. He should have certainly been prevented from doing what he was. He should have been stripped of his judicial office, but maybe he shouldn't have been imprisoned for what he did.
Advocate Bhushan, if criticizing the court or its functioning is met with contempt proceedings, then what is the way ahead to have a constructive discussion about, about the Supreme Court, about how the Supreme Court functions, or as a matter of fact, the judiciary itself?
Yes, obviously, for any discussion or frank discussion about the judiciary with a view of seeing how it can be reformed, you need a frank expression of opinion about what is wrong or what is right about the judiciary. And if you say that, look, this is wrong, or there is so much corruption in the judiciary, or that the judges have lost their independence, and if that is going to be treated to be contempt, then obviously there can never be any discussion nor reform of the judiciary, because one prerequisite of any reform is a free and frank discussion of the problem.
Advocate Bhushan, after this case, will we see a new version of Prashant Bhushan in the Supreme Court? A lot of people have this question, like, what do you hope to achieve by being a constant critic of the judiciary?
Well, I hope to, at least in this case, I feel that public attention was drawn to the functioning of the Supreme Court in the last 6 years. And whenever I say something about the functioning of the judiciary, it is with the view to focus public attention on what I see as a problem, with a view to reform. As I have been saying, that the judiciary is a very important institution, especially the Supreme Court. It is the last bastion of hope for the people who come to it for redressal of the violation of their rights, for protection of the Constitution, for protection of other important institutions. And therefore, it is important that the judiciary survives, it remains strong, and it remains independent. And whatever I've been saying about the judiciary has been saying in that spirit, with a view to reform.
Advocate Bhushan, my last question is something which is to set a lot of rumor mongering straight. There has been a lot of discussion and buzz over Twitter that, and legal opinion seems divided on this fact, that if a lawyer is held to be in contempt by a particular court, then that lawyer cannot practice in that court. Is that of any, like, there are past precedents, it was being argued, etc. Like, if you are being held in contempt by the Supreme Court, then you cannot appear before the Supreme Court. Is it correct in any way?
I don't think so at all. It's like saying that if a person has been convicted of any offense, he should thereafter not be seen in society, etc. That is not the point. See, they have sentenced me to ₹1 rupee fine, which I will pay under protest. But that does not mean that just because I have been convicted for contempt, I should not practice before the Supreme Court. I don't subscribe to that view at all.
And as we end the interview, sir, any parting thoughts on Justice Arun Mishra? He retires from office today, and there was a farewell in the Supreme Court for Justice Arun Mishra, where Chief Justice of India, S.A. Bobde, spoke on him, along with other top law officers of the country. If I could just hear some words from you for Justice Arun Mishra on his farewell day.
I heard about that farewell function, and I read that Mr. Dushan, the way the president of the SCBA was prevented from speaking in that function. That was very unfortunate. And he has said that what he wanted to say to Justice Arun Mishra, he was just going to wish him well. In the same vein, I also wish him well. I feel that retiring judges, especially those who have been involved in doing a lot of politically sensitive cases in which the government had an interest, at least they should not be accepting any post-retirement jobs in which the government plays any role whatsoever. So I hope that Justice Mishra will not be offered, nor will he accept any post-retirement job in which the government has to play any role.
Right. Thank you so much, Advocate Bhushan, for being with us in this interview, and we really look forward to have another interview with you in the coming future. Thank you again, sir. I wish you all the best.
Subscribe to our YouTube channel and click the bell icon.